Hello and good evening. Olá, boa noite to this, the Expats Portugal webinar for the 12th of June 2025. A very important webinar, Essential Estate Planning for Expats in Portugal. Important because it's easy to make assumptions around this subject, which can be very difficult if not assessed and challenged, which is exactly what we're going to do tonight. We can check our assumptions and find out exactly how to do this in Portugal, safeguarding our assets and loved ones. Show your love beyond a lifetime by planning now. And Andrea Gonçalves from Reis Pelicano is here to do that with us. We'll be looking at inheritance rules and taxes in Portugal, what happens without a will and key considerations about taxes. Estate planning, how to manage your assets effectively to ensure your wishes are honoured. Writing a will in Portugal, the process, the costs, and the importance of having a valid will in place. Portuguese law considerations, applying laws from your home country, if you can do that. Excuse me for a moment. Sorry. Assigning power of attorney, your POA, understanding the complexities of having a POA, organ donation, and funeral options as well. So here, our expert speaker this evening. Great to welcome you, Andrea Gonçalves. How are you?
Great. Thank you very much for having me. It's always a pleasure to be with you and to share some knowledge on especially this matter, which I'm kind of fond of.
And it's a very important subject. Was I right to say that sometimes people arrive with assumptions that can be a little bit difficult and challenging if they're not reviewed and we don't take a look at them in a situation in a session like this?
Yes, especially when people think that they have in their home countries a will that will protect them and want to make sure the will is applicable here in Portugal. And sometimes they say, okay, I already have a will, I'm protected, and coming to Portugal, living here, things are quite different and can become very, very complex.
Yes, indeed, as we'll find out this evening. So over to you. You have a presentation for us. Andrea Gonçalves and the team at Reis Pelicano can be, of course, found in our Expats Portugal business directory. And thank you to the premium members who are here tonight. Join them if you want to be live here with us and ask questions alongside the Expats Portugal premium members. Sign up at expatsportugal.com. Right, Andrea, I think you've got co-hosting rights to your presentation on the screen for us.
Thank you very much. And I have prepared here a little presentation for us to ease the process of understanding things. Of course, that I will leave some time for us to talk a little bit if any questions are raised. So today, and as we have brilliantly been summarized here, I will be talking to you about the essential estate planning for expats in Portugal. And so the first thing that I would like to present you is that if you are residents in Portugal, the Portuguese law will be applicable to your succession. And you may ask me, is it only for my assets in Portugal? No, it's not. It's for your entire succession. So this means that all assets you may have worldwide will be ruled by the Portuguese law. If you are, once again, considered a habitual or tax resident in Portugal. If not, it will be the law of where you are resident that will be applicable. Here, the Portuguese law, I'm just going to briefly summarize the main points and why it's so complex and why we advise people, especially foreigners, to waive or try to waive the Portuguese law. Firstly, because in Portugal, we have forced heirship. This means that we cannot dispose freely of 100% of our assets. We're going to see that we can only dispose via a will of a small portion, the equivalent of 1/3 to the estate of someone, or my assets, for example, and I am mandatorily obliged to have class of successors. As we can see, our Portuguese civil code states that we have, before the state, 4 class of successors. We can only pass to the second one if the above one is not met. This means that in Portugal, and according to the Portuguese law, the spouse and children or grandchildren are the first heirs. If there are no children or grandchildren, the spouse and the parents or grandparents will inherit. If these do not exist, then we will pass on to siblings and their descendants. Then we have, if the three above do not exist, other collateral relatives, such as uncles, aunts, cousins, nephews, and nieces. And in the worst case scenario, where we do not have anyone left here to leave our assets, then the state will inherit. Afterwards, the application of shares to the state distribution is always and also mandatory. This means, as I was stating, that we can only dispose freely via a will of 1/3 of our assets, because the other 2/3 must be divided to the legitimate heirs. For example, and just to let you know also that it is very common in the US that when someone dies, they say, I want to leave the globality of my assets to my spouse. And only after my spouse is deceased, then I will leave it, for example, to my children. In Portugal, this is not possible. Spouse and children, or spouse and parents, are going on the same stage to inherit the assets. Of course, that afterwards they will have between them different shares, but we cannot eliminate the children and inherit only for the spouse, for example, okay? And you may ask me, so how can I waive this? There is a European regulation, Regulation 650, 2012, which allows people that have another nationality, rather than the Portuguese one, to waive the law of the residency and choose the law of their nationality to rule their entire succession. And this is here the most important thing that we say, that a person, a foreign person living in Portugal, and even if they do not live in Portugal but have assets here in Portugal, should consider. Is the law of my nationality better for me in terms of asset disposal? Normally, the answer is yes. Portugal has one of the most complex succession laws in the world, so we try to waive that. We can do that via the law of the nationality of a person. Second question, what if I have 2 or more nationalities? Then you're the lucky one and you can choose the one that better fits you and is better for your interest as well. And this is what the first thing of what we can face here in Portuguese laws. Okay. And then we pass on after deciding, okay, I want to draft and sign a will in Portugal. I want to choose the law of my nationality, and I want to dispose of my assets. And here to say that once you choose the law of your nationality, you are able to dispose your assets in Portugal according to that law. It does not have to do with the Portuguese law anymore. Then we are going to advance to the writing of a will in Portugal. Going very briefly, we identify the parties. We choose the law applicable to rule the person's entire succession, as I was stating, not only Portuguese assets. And then we make all dispositions according to the law of the nationality of the certain person to rule the process. So in this case, we usually make dispositions, although people can say whatever they want in the will and express their wishes for the future once they pass away. Normally, what we are interested in is easing the process in the future for registerable assets. And I'm talking about, for example, houses, plots, boats, vehicles, bank accounts, which may seem simple, but then the bureaucracy in having access to the amounts that are deposited in a bank account is very, very difficult, because once bank entities know that the person has died, they will immediately block the account and the heirs cannot access it. So these are the main things. You can tell me, Andrea, I want to do other dispositions. Sure, we can. We can have dispositions about specific movable assets. jewelry, pieces of art left to certain people, pets, who I want to leave them to, how are they going to be taken care of? That's perfectly possible also to do in a will. You can also ask me, Andrea, I don't want to leave this to a family member. There's an association that I do like very much, the work that they're doing, either in Portugal or a foreign association. Can I leave assets to them? Yes, you can. In Portuguese, it needs to be formally incorporated, let's say it that way, constituted. If it's foreign, it will need a Portuguese NIF. Small bureaucracies that may be needed in that case, but it is also completely possible to leave your assets to an association. We will see the implications of taxes in this case. However, it's possible. And also, it has been raised. We have had some clients that have been asking questions about the next thing I'm going to talk about is, can I set up and establish a foundation after my death? Yes, you can. So there are specific rules, of course, namely the minimum capital of 250,000 euros that the estate needs to have. However, this is totally possible, and it can be done in two ways. Or you leave it open, you have the assets, you leave it open in the saying that I want to create a foundation, and you leave people to create that foundation. Or you are also able to leave the foundation totally made and determined, so that once you pass away, it is immediately constituted and you know exactly the terms and conditions that you have set are going to be met. Okay. This is a study that needs to be done case by case, but it is possible you can leave a foundation after your death. It doesn't need to be incorporated or established at the time of your death. Afterwards, we will pass on to still the formalities of writing a will in Portugal. I'd like you to know that the will is an individual instrument. We do not have the possibility of joint wills. This is very common. It's a very common question among couples. They say, Andrea, our wills are going to be the same, but just vice versa. Can we do a joint will? No, each one of you will have to have their own will. It can have or not exactly the same content, but then we will need to do two separate instruments. You will need a translator if you do not understand Portuguese fluently, because the will be drafted and signed only in Portuguese. And also, it is mandatory that at the day that the will is signed, with the translator, the person that's going to sign, and the notary, it is also present two witnesses. It's very important that these two witnesses are chosen based on two criteria. They do need to understand Portuguese fluently, and also they cannot be family related between themselves nor with the person that's going to sign the will. And in any way, as well, they cannot be inserted in the will to receiving any assets. The wills are, in its majority, we help people prepare the wills. I used to say that the complexity of the process is on my end, and you just need to show up to sign. That's basically what will be done, because all the process is normally done between us and the notaries. The notary is the only person in Portugal that has such powers that are provided by the state to register wills, archive them, and make them enforceable. So if a lawyer tells you, I'm going to do a will for you, they will help you draft, they will help you understand terms and conditions, but they will not make the will valid nor enforceable. Okay? The will is then, once signed, each person will be granted a copy, a certified copy of the document to keep. But the original version will always be kept on the notary that you have signed the document with. Afterwards, The notary will communicate the existence of this will to the Instituto de Registros e Notariado, the National Registry Institute. And here is where we know we can have access to it online. This is where we know if a person that has died has left a will or not in Portugal. During lifetime, a will certificate can be requested only by the person that has signed the will. If the person has passed away, we will need to present a death certificate and then request this inheritance or this will certificate to access and know if some person has received or done a will or not. Also about formalities, it is also asked very much if people want to do alterations. There's a name that needs to be changed. There's something that was bequeathed to someone and now it wants to be to another person. Can I have amendments or codicils that are very common in other countries? In Portugal, that's not possible. This implies that we revoke the Portuguese will, any prior Portuguese will, and then we have a new will drafted, even if it has the exactly same content, just changing one word, one name, anything, okay? So in Portugal, you will only have one will with no amendments. After we have the will, or maybe those were the formalities, also something to consider before signing a will is taxation in inheritance. Is the person, am I taxed? Is the person who's going to receive my assets going to be taxed? It depends. So I would not like to talk about taxation in inheritance and wills, but we only have the figure of stamp duty, imposto de selo. Just to let you know that when someone has assets here in Portugal, and especially if the person is resident here, the heirs of that person have to communicate the death to the tax authority. It is mandatory, otherwise a fine may be applied. If you have never had a fine by the tax authority before, 25 euros will be applicable to you, otherwise it will start increasing. So here, how do you do that? Just need to go to the tax authority and request the information. You need to tell who are the heirs, which are the assets, and they will help you through the process. This needs to be done until the end of the 3rd month after the person has died. So if someone has died today, July, August, and September, until the end of September, the last day of September is the deadline with no fine applicable to declare the death and have the stamp duty also issued. There is a rate. The rate is 10% for all assets that are inherited by someone. And if we are talking about plots or properties, real estate, there's an increase of 0.8%. This means that in all assets are taxed at a rate of 10%. Real estate transfers are taxed at 10.8%. However, this is not applicable to all people. There are exemptions, as we will see. The application is to all assets that are inherited or received as gifts in life. Donations are also subject to this 10% or 10.8% rate. And it's applicable to the assets located in Portugal or if the deceased person was resident in Portugal. As I was telling you, there are exemptions to this. Spouses, children, grandchildren, and parents and grandparents are not subject to paying taxes. They're exempt. Other heirs, siblings, nephews, friends, unrelated individuals, such as, for example, the associations that I was talking about minutes ago, are liable to pay this stamp duty. So this is also something relevant to think about when you do want to leave assets to any people that are not exempt from this tax, okay? Scope of taxation, because here it's very frequent that people do not only have assets here in Portugal, they have assets worldwide. These these taxes, stamp duty, is applicable to Portuguese assets, any Portuguese asset that may be registered. And we are only talking about, once again, registerable assets. Of course, that if you say, I have the chairs, the table, the bedroom, that's not an asset that's going to be subject to tax, okay? So it applies to all Portuguese tax. Foreign residents inheriting assets in Portugal are subject to stamp duty, and Portuguese residents inheriting foreign assets may face other tax obligations. And this will depend on the double taxation treaties and the laws of the country where the assets are located. So please be aware that when we talk about taxes in inheritance, and we are only talking about the stamp duty, it applies to assets in Portugal. In other countries, there may be other taxes applicable that we are not able to know at the time. We do not have inheritance tax treaties. However, as I was saying, we do have some double taxation agreements and capital gains treatment. So that may be also something to consider before advancing. Trusts are there are a lot of people familiar with them. We do not recognize them under the Portuguese law, so we do not have that figure. We are not able to do anything similar to that here in Portugal, okay? This means that I have a property here in Portugal that I want to leave to someone, or I cannot put it in a trust to be used or executed by someone. I need to leave my assets to a predefined person, rather it's a legal or a natural person. Also, as I was stating, and just to remember, gifts during lifetime, because it's very common sometimes that people say, okay, I don't want my children to get angry between themselves in separating my assets. I'm going to donate everything during my lifetime. If this happens, and if it's not to the people that we have seen as the spouse, descendants, and ascendants, they may be subject to the 10 or 10.8%. Okay. In terms of taxes, this is the main comments I would like to make. Then we have another very common instrument used worldwide, a durable power of attorney. Is it possible under the Portuguese law? When I talk about a durable power of attorney, I'm talking about a legal document that allows someone to appoint another person to make decisions and act on their behalf, remaining into effect if the principal becomes mentally incapacitated or cannot rule their life. These powers of attorney are not valid in Portugal. They are not enforceable. Even if you say, I have a durable power of attorney in the United States, it's translated, it's apostilled, I want to make it enforceable here in Portugal. Any entity may refuse it because we do not have this figure in Portugal. You may ask me, so Andrei, if something happens to someone, are the assets going to be stopped? Are they going to be left without no regulation? No. We do have two figures here that can help solve this problem. Two key instruments that are very similar to the durable power of attorney. One of that is the Testamento Vital, healthcare directive, or the advanced directives of will. We have been talking until now of a will that will rule my assets, my financial assets, anything that I have. Now, when we talk about Testamento Vital, we're talking only about a will that is done within the SNS, the National Healthcare System, that's going to rule what I want or do not want to be applicable to me in medical terms. And then we also have the regime, o regime do Maior Acompanhado, which is the accompanied adult regime. This is the regime that we will need to use if someone needs to dispose their assets and is not able to do that freely. In terms of the Testamento Vital, with the Testamento Vital, you have the possibility to name a healthcare proxy, representative who can take these decisions, medical decisions, if you're not able to express your wishes. And you are also able to state the types of medical treatment that you do, or do not want to be applicable to you if you're not able to, at that time, express your wishes. This is very, very, it wasn't used in the first years that this was created, but it seems to me that people are more aware of this instrument. It's typically, it's a free instrument that you can use. SNS is giving you this opportunity. So I think that people are getting more and more used to it, and more used to thinking about these matters in this case. The document must be registered within the National Registry of Advance Directive. We call the RENTEV. It's valid for 5 years. If you do not alter it, it's automatically renewable, okay? You also have access to it. You need your Portuguese SNS number enforceable. It needs to be in place. Otherwise, we're not able to do that because it's in direct connection with the SNS, the healthcare national system that we have here in Portugal. And you are able to access it through your online portal as well, okay? Once again, please note that the Testamento Vital only applies to medical decisions, not financial matters. Financial matters are from the will done at the notary that we have talked about. And then, for any assets that need to be ruled by a person that is not able to do so, we have the regime do Maior Acompanhado, the accompanied adult regime. It's a regime that we need to have a lawsuit in place. We need to go to court. People are going to be heard. But this is to protect the person. So it's a document, and it's a decision that entered into effect in February 2019, before we had 2 other regimes that were not applicable, that were no longer okay to be used, and so they needed to create a more flexible and individualized approach to supporting adults. Here we're talking about adults only. And so if someone is to have health issues, disabilities, certain behaviors, and are unable to fully exercise their rights, this is the regime that we need to follow to have it ruled. Also, this regime will create, so the person will be heard. There's documents that we need to provide that the person is not okay, and the judge will create tailored measures to the individual's needs. So we cannot say that that will follow, every case follows the same path, because it is tailored for each person. The individual can choose their accompanier, and the choice should be respected. But if the person that needs this regime cannot decide of who they want to choose, then there are other people that can do it. For example, the individual, as we were saying, can make this request to the court, or a close relative, the spouse, the partner, any descendant, any child. It can be the public prosecutor if they have the knowledge that this person is not able to rule their assets by themselves, or if there is a legal representative. For example, the person that has the durable power of attorney that is not enforceable in Portugal can make this request to the court in Portugal to have this ruled. And the court will decide what the person that needs this regime can or cannot do, or what the person that is accompanying the adult can or cannot do. There are, for example, spaces where the person that is going to make the decisions by this accompanied adult needs the authorization of the court, for example, to sell properties. So it's a regime that's thought on the well-being of this adult who needs this regime. Okay. The individual, as I was saying, must be heard by the judge, and a medical examination is typically made to assess their condition and the need for the accompaniment. This is made so that everyone is aware that the person is not in conditions, mentally conditions, to rule their lives, because there may be also requests that people want to make the court think that they are not okay, and they are. So medical examination and the hearing of the judge is not waived, and then the judge will make their decisions. Another thing that is being done and heard here in Portugal. Portugal is among the top countries of the world for organ donations rates per million population, largely due to the efficiency of its presumed consent. What does it mean? In Portugal, all citizens are considered organ donors by default. If you do not want to be an organ donor, you have to expressly say it. So instead of saying, I want to be a donor, you have to do it the other way around. We assume that everyone is a donor. If you do not want to, you need to declare it expressly. This is done by Renda. It's a national registry of non-donors as well, okay? So it's not in the vital will. It's not on the financial will. It's a new request that needs to be made with this national registry. The organ donation is considered only after the confirmation of the brain death. This is coordinated by the hospital, the transplant teams, and it's verified by independent medical teams as well. And this is especially when the deceased wishes are unknown, okay? You can tell me, Andrea, are the documents, the doctors, sorry, going to ask the family? Yes. It's not mandatory that they do so. They normally ask the family if the wishes of the person are not known before taking that and before proceeding. They normally ask the family if they agree. However, they do not need to do that because, once again, it's presumed that the person will donate their organs after their death. So in this type, it's quite simple as well to have that done. This needs to be done in person. So this is not an act that you can ask a representative to do. This is not something that needs to be sent via post or email. This is the registration that needs to be done in person at a health center and through the official forms that the SNS has for this purpose. And all after this, we reach funeral options here in Portugal. In Portugal, we do have several funeral options. There are some that are the most traditional ones, but then we have other ones that are raising here, and I do think that we will accompany other countries that have more eco-friendly funerals, let's say it that way. Here, when we want and we need to have a funeral regulations, we need to go to the municipality and see the national laws. So because municipalities have a lot of interference in these matters. Firstly, we need some legal and bureaucratic requirements. The first thing to do is have the death registered at the Civil Registry Office, the Conservatório do Registro Civil. This is the registry not only for births, for marriages, divorces, is also for deaths. So this is the Conservatório do Registro Civil will be the entity that's going to provide you the death certificate. You will need it for everything after the death of someone. Then funeral homes, they're quite handy in these matters. They know that the people are suffering. They know that the people don't know, the family members don't know what to do in these situations. So funeral homes often handle most of the paperwork on behalf of people. Okay. We have several types of funerals. We have the most traditional ones, that is the inhumation, which is the burial. It's buried in a cemetery, in graves or tombs. It also can be buried, the body can be buried in family plots or rented graves. However, regarding burials, we will always need, whatever we want to do, we will always need the approval of the municipality. Okay. So we cannot just say, okay, my beloved one has passed away. I have a family grave. I'm not going to tell anyone, and that's where the person's going. No, you need approval from the municipality at all times. Religious rites are often part of the services offered as well. And normally in Portugal, grave maintenance, whether you purchase the grave or it's rented, it's always the family's responsibilities, unless other things have been arranged. Okay, then we have cremation. Its growing popularity, especially in our main cities, Porto, Coimbra, Lisbon, and they do exist already in these major cities. The ashes as well can be buried in a cemetery, or can be placed in the columbarium niche. If you want to scattered in designated areas, it also needs approval. So you cannot say this person wanted to be left on the sea and you just go there one day and throw them. Please don't do that. You need approval from the municipality. You cannot do that in the place where you deem most convenient, or where your beloved one wanted to be left. Eco-friendly funerals, they're not quite common here in Portugal. They're still limited. This also because the coffins, for example, our national law states what type of wood you can use. If you're going to be buried, you have to use one type of wood. If you're going to be cremated, you need to use another type of wood. So this is something that's still under development. We're starting to see it rise, and we know that these funeral homes are now offering other options. But still, they have some limited things that you can or cannot do. We also have the municipal cemeteries that they follow traditional practices. So green burials that worldwide are seen, the green burials require special arrangements and municipal approval as well. So as you can see in this case, it's not only the national laws, but especially what each municipality decides for this matter in their territory. Okay. And also we have the human body donation. I'm not still before the repatriation. We're going to the human body donation. Your body, you can decide that you want to donate your body to science, for example, for a university. This also must be arranged before death. It needs clear written consent as well, okay? And in these cases where the body, you state that you want your body to be donated to science, and anatomically study, for example, for university, the family is usually not charged for the transport or for the funeral after the studies are complete. Normally, remains are often cremated or buried by the institution itself. Okay. And then here we reach the end of what I would like to share with you today, which is repatriation. You live in Portugal, but you may want to return home, or to your first home, or anywhere in this world that you think you would like to have your last residence, let's say it that way. This implies strict laws, and this needs coordination between the Portuguese authorities with the foreign authorities. So in short, once again, it's very important that you have the death certificate. It needs to be issued, but instead of having it only for Portuguese purposes in Portuguese, it should be issued in an international version. and it will need to be apostilled to be used abroad. Okay. You will also have to coordinate documents with the Portuguese authorities and embassies and consulates. This includes the death certificate. It may also include medical documentation stating what was the cause of death of the person that's issued by the hospital. Requirements of embalming. In this case, if it's going to go abroad, it needs to be embalmed. So this needs to be taken care of as well. And there are countries that demand that a non-infectious disease certificate or an equivalent document is issued. Okay. Also, you need to have in-course specific arrangements with transportation, and these are strict coordination between Portugal and the country of repatriation. So I have presented you here a summary table. First is the death registration, Portuguese civil registries, medical documentation for the cause of death, health clearances with the hospital, embalming, that's mandatory for abroad transport, transport authorizations. Normally this is done via plane or via car. Any other can be held, however, this needs to be taken care of. Embassy consulate has to be informed because they will assist you with documentation and coordination with the foreign country. Transport and arrival formalities as well. I think that we have gone through the main points of estate planning. I know that this is a world that I used to say, and it is a world that it's one thing for each person. So these are general considerations, and then we will have to see case by case because one thing can alter very differently from others. I hope that I have clarified some of the questions you may have. Others I will be very pleased to answer and to chat. Thank you once again for having us and for this possibility to share some content with you.
Outstanding, Andrea. Excellent presentation. Thank you very much. A difficult subject and a whole day at work for you, and then a fabulous presentation. Informative, very helpful and enlightening. So thank you for being here this evening. And we do have some questions for you. If you can bear with us for those, that would be fantastic. Including what happens if someone dies without a will and there are no known family members? That's a big question. What we'll do, I think we'll save that one for when we're talking to you when the recording is finished for YouTube, and we'll share that among the premium members. It's a good reason to be here and become a member and join us for this session after the recording. But I will take a few sort of more general questions that will be useful to people who are watching and of a more sort of universal nature. This is I think probably a finance tax one. We might need to refer this elsewhere. But in the US, accounts such as the 401k have designated beneficiaries. These are who gets the assets no matter what is in a will, as I understand it, says Beth. Does this still apply for a Portuguese resident? Can you help with that one, Andrea?
So the beneficiaries here and who are getting the assets, I believe, are the same people, right?
Yes, I think so. If not, Beth,
Okay.
do let us know.
So in this case, if you want to leave assets to a specific person, it needs to be stated in the will.
Right.
Okay. And afterwards, even if the person is not resident in Portugal, it may be resident in the US. If it's
Yes.
inheriting assets in Portugal, and if it's not one of those people that are exempt from the payment of the stamp duty, taxes will apply. I
Okay.
think that was the question, if I have answered properly.
All right, thank you, Beth. Perhaps again after we've concluded the recording, we can open that up a bit and chat. David asked, had to go away urgently whilst you were speaking there. Am I able to view this recording later? Yes, absolutely, David. There is the YouTube recording, but also for premium members, we have the whole recording, including the questions and questions that people send in who can't be here, because we have some of those this evening as well. Who can be appointed as the executor of a will in Portugal if we do not have any close friends or family members? This is a great question from MI. would it be a good idea, Adsbeth, to have someone, for example, a lawyer in Portugal, be the executor for relatives in other countries? They would not only have a hard time perhaps with the bureaucracy, but a hard to get the details sorted at a distance as well. So yes, will you work on behalf of people, Andrea?
Yes, that's something that we can do as well. So normally people are more comfortable in having family, friends as executors of their will. This
Yes.
is something that is also stated in the will at the time of it being drafted and signed. But this question raises a lot of time. So, Andrea, I do have family members. They're not here. They don't know how to work with the system. Uh,
Right.
can I have a lawyer intervene? My accountant intervene? Yes, you can. So it's up to you to decide who you want to rule or who you want to help execute your will.
Right. Okay. And clearly, Rez and Pelicano are
Let
well
me
versed in this.
just do an update on this.
Yes.
Please note that people who are inheriting, people who are receiving bequests need a NIF in Portugal.
Yes.
Sometimes it's something that we forget. I'm going to inherit something in Portugal, a plot in Portugal, but I don't live there. But you need a NIF.
Of course. Of course you do.
Always the NIF.
Always the NIF. Everything leads back to the NIF here in Portugal. With respect, Diana B, excellent question, as ever, Diana. With respect to the Testamento Vital and the Regime do Maior Acompanhado, if one has a US named healthcare proxy, can one name that same proxy in Portugal?
Yes, it can.
Very good.
You
Okay.
can do exactly the same thing that you have done back home
Yeah.
here in your new home. So one thing does not take away the other. We can
Okay.
do it exactly the same way here in Portugal. Yes.
All right. Okay. I'm going to leave it there for our YouTube viewers. So thanks again, Andrea. Is anything you'd like to say as a last word for that recording? Of course, you can be contacted via the Expats Portugal Business Directory. Anything else you'd like to add before we pause the recording?
Yes, I think that this is something that people should think about. Once again, our Portuguese system and laws are so complex that if anyone has the possibility to waive the Portuguese system, being a foreigner, I would advise to do that.
Very good. Excellent. Speaking from bitter experience, I suspect, on behalf of others. Right.
Yes.
Thank you, Andrea. We'll leave it there for YouTube. Thank you for watching our video. Please make sure you subscribe and think about becoming an Expats Portugal member, of course.